So this last panel is a feature now of our discussions and the conferences we organized, the ICF, the engagement with the stakeholders, in particular the non-usual stakeholders so far, but I think they'll become more usual from now on. And I think, as far as I understand, there's been some organization between the stakeholders to develop common points that will help also the Commission in their work in terms of redrafting the guidelines, the draft guidelines to a certain extent express also the concerns and represent the concerns of the stakeholders. So we have a large group of different interests being represented here. I'm not going to have too much time to present each of you, so I think we'll just try to focus on the discussion. So I would like to start by asking Vanessa Turner from BEL to intervene and particularly react a little bit to the draft guidelines. And what is your perception as the main consumer organization in Europe about the guidelines, and what is really missing or not from the guidelines? Vanessa, the floor is yours.
Thanks. Right, thank you. Thanks. I will come to the guidelines, but I'd like to raise a more philosophical,
absolutely,
broader
even better
first, as our panels will feel that way. So I want to look at whether competition law is fit for European consumers more broadly, and look at that in two ways, including one or two. My short answer is it's not fit in its entirety, and there are ways that it could be made better, and ways that I fear it could be made worse. And the primary area where I fear it could be made worse is in relation to merger controls. So I'm going to look at that first, and then I will turn to 102. So my fear for merger control is because merger control is an absolutely critical element of competition policy, because prevention of the ability to abuse market power is always going to be better than trying to cure it ex post. The effects of lack of competition on the economy and on consumers are shown by the Commission's recent report, Protecting Competition in the Changing World, which shows, for example, that in countries with 3 telecommunications operators, these countries have had consistently higher prices than those with 4, and for airlines, prices per mile are higher for consumers where the airlines have a monopoly or duopoly route. The empirical research in this report has also pointed to the negative relationship between market concentration and investment. And for me, this makes maintaining the merger control approach that we have today essential for competitiveness, and not weakening it to try to create European champions or to solve lack of investment. So obviously, you're realizing that I'm referring here to the Draghi report, which for me has good points and bad points. And I think it's striking that whilst that report states, and I quote, "The evidence is overwhelming that competition stimulates productivity, investment and innovation," then other sections of the report cast or appear to cast aside this overwhelming evidence. So if I look at the way that it deals with telecoms mergers, suggesting that they should be analysed on the basis of European markets would fundamentally undermine one of the foundations of European competition law, and that is looking at competition where it actually happens. Similarly, the suggestion in the Draghi report to clear anti-competitive mergers on the basis of commitments to invest sounds like a good idea in theory, but how will it work in practice? How do you force a company to spend money effectively if it doesn't want to? What sanction do you impose for breaching the investment commitments? Do you require that merger to be broken up again? Or do consumers end up being harmed by the uncompetitive market structure that is created by the cleared merger without the promised benefits? And I think similar questions arise in relation to the report's suggestion for a non-sector specific innovation defence. So there I do have some issues with the Draghi report. Where I do think there should be a change in merger control, however, is in relation to killer or nascent competitor acquisitions after the Illumina Grail case. This now loophole needs to be closed quickly before there are further anti-competitive mergers with harmful effects for consumers and society in general. We see, for example, that big tech, in trying to control AI, is already attempting to get around merger review through creative structures such as employee hiring rather than buying companies. So I think the fastest route to close that loophole may be call-in powers at member state level. So I'm looking at the remaining NCAs in the room for that. And I would add one final point on that, is I think we need to be able to review the potentially anti-competitive killer acquisition, all such potentially anti-competitive killer acquisitions, not just those by foreign companies, as is stated in the mission letter for the Executive Vice President designate. So now I will turn to 102. We talk, and now I'm going to react as well to what people said, we talk often about being in a Brussels bubble. But today, I actually feel like I'm in a parallel universe. And previously, I've been surrounded by lots and lots of criticism from the usual lawyer and economist suspects on the draft guidelines. And maybe one can argue about some of the details, as has been illustrated today. But for me, these criticisms miss the big picture point. Article 102 has not been working in practice for the welfare of consumers, its intended purpose. What is the point of having this treaty article if its effect in the real world is blighted? This might suit the companies who abuse their dominant position and their lawyers and economists who enjoy running lucrative intellectual thought experiments or playing games, as Jean-François Belly said earlier on, which last sometimes years or even decades. I don't think that's what the treaty drafters had intended, and it's certainly not good for consumers. We, as consumer representatives, have been party in 4 digital abuse cases in recent times, and the speed of those cases, as has been mentioned by others, is absolutely glacial. If I look just at the one that's been mentioned a lot already, that we were involved in also, the Google shopping case, that's now finally been decided, but it has taken more than 15 years, and in fact there's still no effective remedy. So we know, in fact, I think that doesn't just apply to digital cases, but all abuse of dominance cases take far too long to be decided by the Commission and the courts, not just the Commission. And as we all know, justice delayed is justice denied. And as also been said on the previous panel, some cases are not being brought at all. And I think we absolutely need to recognise that under-enforcement is ultimately a policy choice. So that was my first universe. This afternoon I'm now in the other universe where people agree that something needs to be changed for the better. It's wonderful. And I think there are certainly some things that need to be adjusted in the draft guidelines, but they are, I would say, at last, a very welcome step in the right direction to improve the current situation and to set out a workable effects-based approach, including the use of presumptions where appropriate and the naked restrictions, and all of these I do agree are built on extensive citation of existing case law. So we can constructively improve the draft guidelines through discussion, or we can continue the current under-enforcement policy. I hope the guidelines are also going to stop some of the time that has been wasted on tortuous legal arguments that have now, in fact, repeatedly been rejected by the case law of the Court of Justice, and I think that is usefully detailed in the guidelines as well. And while there's many other things I could comment on, I'm just going to focus on one main one and 2 smaller ones, I think. Because as a consumer representative, I think I have to comment on the concept of consumer welfare or welfare of consumers. In my view, EU competition law, despite what some economists, though not Anna Sophia, has suggested, we have never had a narrow consumer welfare concept as in the US. It's not a price-centric concept. Or consumer welfare. The case law has shown that we cover much broader values. If I look at the case law, the court has in fact consistently found that we have that Article 102 is capable of protecting multiple interests, not only price, choice, quality and innovation, as has already been cited, but also consumer well-being, the functioning of the internal market, and effective structure of competition, the well-being of intermediary and final consumers as being the ultimate objective of 102, including, for example, plurality in a democratic society. And the broad scope of the 102 scope is, I think, well summarised in the Super League judgment, which states that its purpose is to prevent competition from being restricted to the detriment of the public interest, individual undertakings and consumers, and that definition is repeated in Google Shopping as well. So I think the scope of 102 could perhaps be more explicitly set out in section 1.1 of the guidelines, also for the purposes of self-assessment and for complaints. So turning very briefly now to two more points, consumer-facing points. The guidelines mentions behavioural biases, so how consumers actually behave and what influences them, in relation to barriers to entry and expansion in the assessment of dominance section. But it should also, rather the guidelines should also mention this concept of behavioural biases or user behaviour more broadly in relation to finding of abuse, where we now know from the court that these the behavioural biases or user behaviour has been recognised numerous times by the court, both implicitly and explicitly, most recently in Google Shopping again. The guidelines mention user behaviour only in relation to tying and self-preferencing, but they should make it clear that user behaviour could also, or consumer behaviour could also be relevant to other potential abuses where consumer behaviour could be part of the specific circumstances that guidelines note must be taken into account in analysing the case. The second point I was going to make is exploitative abuses should be included. I think that's now been said sufficient times, so I won't say that. Won't go into that any further. But then, just as a final thought, I would very much agree with the speakers on the previous panel that said that the guidelines alone, or changing the guidelines, or creating the guidelines alone, is not going to be enough to deal with under-enforcement. And I couldn't agree more that we need a new competition tool or market investigation tool for all the reasons that Martijn mentioned earlier. But then coming back to the guidelines, I think that is step one, and we should still fight the other issues as well.
Well, thank you. Thank you very much, Vanessa, for these points, and of course the question about the goals and how actually that might fit in better in the guidelines. I think it's in the guidelines in view of the recent cases of the court that seem to be a little bit more open. I think that's a very good point, and I agree. The next speaker is Claire Godfrey from Balanced Economy. Claire, the floor is yours. So the idea is to discuss about the future of competition law. It fits with the social contract, in particular referring to the guidelines, but not exclusively.
Thanks, Yanis. Yeah, so good afternoon. I'm Claire Godfrey, Executive Director of the Balanced Economy Project. And I'd like to thank Yanis and ICF for inviting us into this space. We have so few opportunities to speak within this, as often said, bubble. So we're very grateful for that. Just to give my comments a bit of context, I'll just very briefly say what the Balanced Economy is about. We're an anti-monopoly organisation with a mission to hold powerful corporations to account and reclaim democratic accountability. In doing that, we support legal and public frameworks that regulate business activities to ensure that they do not undermine human rights and the public interest, particularly in areas of excessive concentration and power. So to start, I mean, I think it's firstly important to state that we actually welcome this initiative by the Commission. It's an important step, particularly if it leads to some progress in tackling uncertainties around the substantive interpretation of exclusionary abuses and and establishes a more coherent evidentiary framework. However, having said that, my comments are more general actually and indirect, and I'll keep them relatively short. Just 4 points. One is language and discourse. Second, and relatedly, definitions and interpretation in discourse, looking at innovation. Thirdly, limitations of effects-based approach. And finally is more of an imperative with an exclamation mark of put exploitative abuse back on the table. So, language and discourse. So we're about power analysis and dismantling the concentrated power, as I said, and power is represented and reflected in ideas, in language and discourse. And in the case we're talking about today on a basic level, it's exclusive and exclusionary in itself, that the competition bubble and all the power dynamics bound up within that is insulated by an impenetrable language and discourse, which undermines democracy, transparency, public accountability, and civil society's ability to influence processes such as this. So I think there's an important point about public engagement, where thinking about a language that precludes inclusivity. And a second point that relates to language are how ideas and concepts are interpreted in discourse, in institutions and political and policy debate. And as I said, take the issue of innovation. There's a rhetoric of innovation, for example, very prominent in big tech discourse. How can we lead the digital revolution, they say, with tough enforcement against dominant companies? This is a false assumption, fast becoming naturalised in discourse. First, innovation often arises from smaller companies and deconcentrated markets. Secondly, many of the innovations associated with technology companies often have their origins in the public sector. And thirdly, innovation is not innately beneficial. Why am I saying all this when it's not directly related necessarily? Is my point is saying to policymakers and the courts probably problematise this discourse so we don't naturalise ideas that we shouldn't. So moving on to limitations of effects-based approach. If DG Comp wants to improve interpretation and evidentiary frameworks, why is there so little critical analysis of the tools it uses to assess anti-competitive effects, i.e. using IO, economics and narrowly defined price-related harms? We know from behavioural economics that we are locked in. We know from financial analysis that there are excessive profits, something the Balanced Economy Project is concerned about, both those issues. But yet authorities use IO methods that do not detect these harms and tells us it's all fine. We should look more towards the way businesses look at themselves in their own financial objectives, and not through constructs like marginal variable cost. The information collected in country by country reporting on tax may help here. That's just a random idea, but so you get the idea of what I'm saying. And finally, exploitative abuse of dominance, I will say it again, where's it gone? It's gone, why? Must do better, I think, the Commission here. I don't think it can be brushed under the carpet, under the too hard category. In one of our reports, we found that for the 5 years to 2022, the top 20 companies globally, the average markups rose to 50%. Double the 25% average markup for the bottom 50% of firms studied. This indicates they are using their monopoly power in these markets to hike prices to keep them high, meanwhile ripping off customers. Does that not count as abuse of dominance? And really, I think, given the concentration of markets is the big issue. I really do think exploitative abuse should be the issue we're talking about. Thank you.
Thank you very much, Claire, for these points. And I think because there have been already a few points about this innovation defense, and I know Max is there, I'm going to abuse a little bit of my position, dominant position as a chair here, to ask him. As far as I understand, Draghi is basically suggesting this innovation defense for specific reasons, only for types of situations in the merger control for tradable, for the non-tradable sector. However, I think the language that is in the Draghi report has led a number of commentators to use this innovation defense in order to also argue for this to be taken into account in the context of antitrust enforcement and eventually also for 102. It wasn't, you weren't listing innovation defense in your objective certification and efficiency defense. Is this something that the Commission would like to take forward, or is it not the discussion which somehow is relevant for the context of Article 102?
I'll be very brief. I wouldn't try and overinterpret what Draghi writes. My understanding is that was indeed the context of merger control, and my understanding may be wrong, of course, but I wouldn't try and overinterpret what it says. That said, of course, we are still in the public consultation, so any idea is welcome.
Great, interesting answer. So let me now move to a specific type of issue that hasn't been important, at least until recently, for competition enforcement, in particular labor. Right? I think it's only recently I've been focusing a lot on effects on labor. Great, thank you very much, Jean-Benoit. Light has come, labor discussions are going to wake us up. So we're very happy to have with us Joachim from the European Trade Union Council, Confederation. So the CIS Confederation. I was trying to find out what was it. So very happy to have you with us, and I think we see a little bit more and more interest from the point of view of labor lawyers and labor concerning the enforcement of competition law more generally, but also I guess also for Article 102. So any views to share concerning the competition law project? Yeah.
Thank you very much for inviting indeed the European Trade Union Confederation to speak here today. And I heard indeed the word labor being used briefly already today, but I thought I would nevertheless perhaps explain a little bit why I'm here today. So at DTUC, we of course look at competition rules and enforcement from the perspective of workers. And what is clear is that competition policies do have an impact on employment, but little is done often to address adverse effects on labor. We see increasingly concentrated markets, which also means concentrated labor markets, in turn meaning employer monopoly power. This means more dominance in the labor market, whereby employers, so to say, as buyers of labor, can strengthen their power over the workers. So, for example, a dominant employer may be able to downgrade or impose certain working conditions on the workforce, which is basically tied to that individual company due to a lack of other opportunities in the sector or in the region. In other words, weak competition on labor market means wages are set below market price. And similarly, there's a risk of unfair labor practices with increased dominance in the labor markets and also declining collective bargaining coverage, which is in fact the tool workers and trade unions have to kind of rebalance those power relations in the labor market. So weak competition among employers for potential employees is in fact as harmful to their economy as weak competition over their products. This is the point I'm making today. And like Vanessa, I would also like to touch on merger control, because this is something picked up in the Draghi report, also echoed in the political guidelines of the von der Leyen II commissions. And indeed, these operations have clear impact on employment, working conditions at the level of the workplace, as well as on the region as a whole, and especially when it comes to structural remedies. So to ensure that competition policies actually deliver on EU objectives such as full employment, good quality jobs, territorial cohesion, European industry, the Green Deal, this, in the opinion of the TUC, needs to be reflected also in the merger policies, the way we assess mergers. Because relevant markets are not only about consumers, competitors, or innovation, but also labor markets, which depend, for example, once again, on the regional aspect, people's skills, possibilities to commute, whether it's a profession that allows you to telework or not. That helps us define the relevant labor market, so to say. So all this can indeed have an impact on the labor market, and I think this is quite clearly reflected, for example, in the merger guidelines issued last year by the US Federal Trade Commission. And to address all these adverse impacts that we might have on the labor market due to more concentration, at the TUC we believe that we should look more closely at, for example, behavioral remedies and more actively involve both workers, trade unions in those processes and making sure we put in place the adequate safeguards. So in terms of, for example, behavioral remedies, what I mean is to, for example, ensure that there are information and consultation rights of the workers, that there's respect for their required rights or promotion of collective bargaining, and likewise, in terms of territorial cohesion and keeping jobs in Europe, we need to find ways to also address the problems we have with mass redundancies, relocation, and at the very least make sure that there are upskilling and reskilling opportunities put in place for these workers. And of course, there are other policy tools in the toolbox, but we believe also competition policies need to reflect on how they can contribute to these policy objectives. Now, a few words also about Article 102 and the guidelines. Of course, we can say they're a step in the right direction and kind of shows a desire to more vigorously apply Article 102. A more principled approach might indeed allow for better factual assessments of various situations. And just to give an example, perhaps from a labor market point of view, when it comes to tying, we think these guidelines should also address lock-in effects that we see on digital labor platforms, because these sometimes make it difficult for people working on these platforms to change between competing platforms. Of course, now there is also the Platform Workers Directive at EU level, which of course offers some protection to those workers who qualify as employees under labor law. But when it comes to those who are, so to say, genuinely self-employed working on these digital platforms, they remain undertakings for the purpose of competition law. And in this sense, perhaps they could also draw some complementary protection from Article 101 and ideally also from these guidelines. But overall, above all, what we are missing, of course, is a clear focus on not only exclusionary but also exploitative effects. I mean, in the labor market today, and in terms of competition enforcement, we see an increase in interest when it comes to, for example, Article 101 and illegal wage fixing or no-poach agreements among competing employers. But we need to start talking also about non-compete clauses, because this is a form of abusive competition practice in the labor market. These clauses are part of employment contracts. They can prohibit workers from joining a competing firm or starting a similar business themselves. And similarly, for example, in the entertainment industry, we see buyout contracts, which often has quite unfair conditions, cutting performers out of all future returns on their work. So these are all forms of unfair practices which make job mobility and market entry very difficult, and especially so in highly concentrated markets. They hamper competition, productivity, and wages, we can say. They're bad not only for workers, but also for consumers, innovations, and SMEs. And once again, looking at the US Federal Trade Commission, this year they launched a federal ban on non-compete clauses, and we think the EU should be going in the same direction. So I'll leave it there for now. Thank you.
Thank you very much, Joachim, for the perspective from the labor movement. I would like now to turn to Mark Dempsey from Article 19. So, Mark, the floor is yours.
Sure. Evening, everyone. It's great to see such a full room, particularly for the last session, which is by civil society. Article 19, as most of you probably know, is a global organisation working on the promotion and safeguarding of free speech and access to information. We've been looking at market power for some time, and I am going to qualify myself here in that I'm deputising for Simonetta Bisazzo, who has much more competition chops than I do. But yesterday we did sit down and we went through the guidelines, and I have some points which I'm going to make specific to the guidelines and which will probably be repetitive to some degree, but I think that's unavoidable when you come as the last platform. So I'd also like to thank Yannis for organising today. I think it's very important civil society in the room. I think it's very clear that there is a lot of competition expertise amongst us, so it's good to be able to showcase that and then pursue. After this, we'll be putting in a joint submission to the Commission's guidelines, which I'm sure will be available for to read at some point. So firstly, I want to state the pretty obvious, the significance of today's event, that though it unfolds in the Brussels bubble, it possesses a distinctly different tone from other concurrent events on this topic, which are predominantly attended by legal and economic consultants, along with the occasional, sometimes independent expert from academia. So having said that, I'm going to confine myself to the observations of the draft guidelines, as the title of this event invites us to do so, because at Article 19, we believe they represent a critical piece of ongoing development in European competition policy, which we deem essential to support and constructively comment upon as a civil society organisation. Although it is understandably difficult to admit, especially about public enforcers, and I used to work for the FCA myself, but not the ones in the rooms, of course, the enforcement of Article 102, as rightly pointed out by the late Professor Heike Schweitzer, has been a failure from the point of view of the public interest and civil society in particular. The length of time it takes to conduct Article 102 proceedings has markedly increased, to the extent that the enforcement of Article 102 has largely become ineffective in safeguarding undistorted competition. This has also had the detrimental effect of diverting resources away from investigation and potentially sanctioning new abuse cases once the enforcer has found itself dedicating all its attention to the few ongoing cases, which had lasted often for several years and had an impact on the proper functioning of market processes that was now completely insignificant. So everything possible must be done to ensure effective, manageable enforcement of Article 102. The current situation serves only the interests of those who gain from abuses of dominant positions and provides the wrong incentives to those who aim to achieve such a position. So, in essence, we're very happy with the draft guidelines and appreciate the way that they've been tabled. However, despite their non-binding nature, the guidelines shoulder significant responsibility for steering the implementation and orientation of competition policy. Not only do they serve to elucidate the substantive law, but they are also instrumental in promoting an understanding and effective enforcement of Article 102 in line with the evolving realities of the market, especially in the context of the digital transition, as we heard a little about earlier on. There are certain aspects of the guidelines that we particularly appreciate, especially for the spirit and approach that pervade them. As for the finer details of these specific elements and suggestions for further refinement aimed at promoting effective enforcement of 102, We will address these in our submissions to the public consultation. The most significant and innovative element of the guidelines are the introduction of the category of naked abuse and the formulation of presumptions for proving anti-competitive effects, of which we've heard much of today. Both of these aspects clearly contribute to promoting effective enforcement of Article 102, and in our view, they represent the very raison d'etre of the guidelines. Much less useful would be a mechanical restating of the case law, although this might be particularly appreciated for educational purposes. It is crucial, therefore, that the Commission draws a significant lesson from the past enforcement of Article 102, particularly in the digital era, the profound issues of which are well exemplified by the very existence of the DMA, as also pointed out earlier today. The modernisation we hope for and promote is aimed at enhancing the effectiveness of 102 enforcement in light of the objectives and values of European competition law. It is not about adhering to the false belief that the only possible modernisation is one that aligns enforcement with specific, limited economic models that offer a false sense of predictability and therefore legal certainty. As various panels have also noted today, the core of the guidelines lies in the confirming of the existence of legal presumptions related to the certain types of conduct that have a high potential to produce exclusionary effects and are by their very nature capable of doing so. Furthermore, it is absolutely positive that there is a clear reaffirmation of the need to distance the guidelines from merely serving as a textbook on industrial organisation. It cannot be that the latest, most sophisticated or most complex economic model dictates the substance of EU competition policy and thus the enforcement of Article 102. And as, again, that was much discussed earlier on. It should be warmly welcomed that the guidelines notably omit any statement suggesting that Article 102 focuses solely on anti-competitive foreclosure and the necessity for direct consumer harm proof. The significant reduction in the importance of the quantitative price cost test and the as efficient competitor test standard should be greeted positively by those who wish to refine the enforcement of Article 102. However, it is predictably opposed by those who benefit from the current situation. As stated in the 2023 policy brief, there are undoubtedly circumstances where protecting less efficient rivals may be justified. Equally positive is that the guidelines clarify that the standards for establishing exclusionary effects is below the bounds of probabilities, again as mentioned today. What we would like to see more of, though, is that the Commission may claim this to be the purpose of the guidelines, is a discussion on the new antitrust priorities, clearly distinct from those largely repudiated priorities guidance. In other words, what is lacking is an articulation of EU competition policy values, not merely operational antitrust goals. Finally, the pressing need to make these and future guidelines more readable and inclusive, in other words, accessible. This is already what Claire has mentioned. The Commission's role in shaping competition policy surely extends to providing tools that help businesses, including potentially dominant ones, often backed up by well-paid experts, understand how specific rules apply to them. Equally crucial is ensuring that the guidelines are clearly not only to the competitors of those businesses, typically small to medium sized, but also to other groups likely to be impacted, especially consumers. The guidelines must be precise yet comprehensible and accessible to a wide audience far beyond just the technocratic specialists. Thank you.
Well, thank you very much, Mark. I mean, I think that the point you made about the fact that the guidelines should be drafted with a focus on principles and values, I think is very valuable. I mean, I was thinking about the US FTC DOJ merger guidelines, were very much based on this idea of principles and values putting forward. And obviously, you know, the draft guidelines might seem a little bit more of a legal kind of a bit dry text. So that's certainly something quite interesting as a comment. So let's now move to Uli Miller from Rebalance now. Yeah.
Thank you. Thanks for inviting us. We are kind of a fairly new German NGO in the field. And generally, I would first of all thank the Commission for this endeavor. I think it's a good one. I think we welcome to have a more principled approach. I think we have heard today about the challenges of 102 enforcement, and I think I remember also Wolfgang Kirchhoff, the president of the German Cartel Chamber of Germany's Federal Court, at the International Cartel Conference, saying, well, there's a need to clip the wings of the more economic approach. And in a way, I think the guidelines are an attempt to do so. And I think that's good. Because I mean, we heard about the problems of enforcement. I think I would also recall that we had the protection competition report in the summer, and that really showed that there's a need for stronger competition policy because we see that there's a rising concentration. We also, I think, one of the data that was really kind of made me think that I think we need to think about more is that we have kind of the share of net profits as part of GDP rising from a few percent to about 20% in 20 years. That is kind of an enormous shift of basically of value appropriation and a shift of power, obviously. So obviously our tools to contain economic power are not sufficiently working. So I think that the abuse of dominance guidelines are a step in the right direction to do so. I think that it could maybe even go further. I liked Damien Gérard's suggestion to think about whether additional practices could be grouped into the third category of naked restrictions. I generally also like that there's an attempt to make presumptions. I think that's good. I thought that also maybe, I mean, there was this question, what does it change? Because then in the end, the corporations will try to rebut them and you will have to deal with the evidence that they submit. I think there's a link maybe to another discussions whether it's appropriate to limit the length or maybe also the number, but maybe more the length of the submission so that this is workable and doable for competition authorities. So then I also appreciate that there was an attempt, at least that's how I read the guidelines or the draft, to limit the as efficient competitor principle and also the test, especially with regards to non-price aspects. I think that's good. I think we heard from Christina about the methodological and data problems with the AEC tests. I would even be on a more fundamental basis argue that efficiency is a problematic kind of criteria in competition policy or for abuse of dominance, especially because efficiency, especially if it's measured in costs like in the AEC, is not independent of economic power, and it can be a self-defeating policy, especially I think if you think of Europe and you have a company that uses its power to change the labor law in another producing countries to run a factory in 2 12-hour shifts, obviously that is efficient in terms of the AEC test in the end, but you could also say it's exploitative, and it shouldn't enable that company to kind of restrict market access for European companies that work under better working conditions. So I think its efficiency is a problematic criteria, or it should not be the end goal of competition policy. I think it's important to keep competition open in the sense that it's not only about costs. I also think that there are some elements in the guidelines that try to do so, that we also think about quality, choice, innovation. I think sometimes it could be a little bit clear in wordings when it comes to paragraph 51, for example, we have this wording that competitors that are less efficient, I mean, in the sense that they can drop out of market, that are less efficient than dominant undertaking, and so less attractive to consumers from the point of view, among other things, price, choice, quality, and innovation, in the view of. And I think, first of all, I'm not sure what the "and so" means, because that maybe could be read in a sense that that it's actually about efficiency then leads to that less attractiveness. But I think I would see it's the other way around. It's actually a wording that shows that efficiency is not only based on on cost, so maybe it's more like instead of and so it's kind of including being less attractive to consumers. So I think there's a wording things on these small issues. I also think that there could be, I mean, it's an among other things wording. I mean, it's taking from, I guess, it's handed down from court decision to court decision and then into the guidelines. I think it might be used, one could think about whether one fully explicitly integrates sustainable in that, at that point, but also in paragraph 55, and I think what Simon Holmes also already mentioned, this that there is this wording about relevant parameters of competition, such as price, choice, quality, and innovation, or prevents consumers from exercising their choice based on the merits of the products, including product quality. I think it might make sense to include sustainability here. I think that I heard Simon in the understanding that it's in a way it's in there. You have quality in a broad sense, but still I think also as a signal when you think about kind of future cases, I think it might make sense to be more explicit. And then I have one thing that is maybe a little bit provocative, but when we always have the discussion about, well, how do we define competition on the merits, and then we say it's about, well, competition on economic operators. Sometimes I think, well, I mean, if you think about competition policy as being about power, isn't the other way you could think of it is that competition on the merit is a situation where companies use their capabilities and their power not to kind of limit or hinder or kind of try to interfere with the competitors. And that, I think maybe it's power is sometimes seen as a dirty word. It's allowable if it's market power or bargaining power, but maybe power as such. But I think it's actually the essence, in a way, of abuse of dominance. Is using your power to kind of trying to counteract the working of your competitors, right? And that might lead, and I think maybe it could be added as an alternative understanding, not replacing it, but because it could help with the thing that Christina mentioned about having a holistic view. Because when you think of it, trying to that you see the departure from the competition on the merits is a strategy where you employ your power to derail your competitor, you can then have kind of a broader thinking maybe that allows you also to see the combination of different maybe practices. And the last point, I'm still wondering if really the question of digital platforms is adequately addressed. I mean, I had these questions today in the panel with Max Kadari. And I take it with me that the point was kind of maybe to be more precise where it could be fit in, but I was wondering that, for example, really if you use your platform power like the buy box to really exclude clients just for the purpose of coercing them to, for example, not offering products at a lower price on a competing platform. I mean, that for me sounds like a quite very, if that shouldn't be seen as something like a naked restriction, something that is maybe similar to dismantling infrastructure, because it's in a way it's not dismantling the infrastructure, but it's excluding you from an essential infrastructure that you cannot have a small kind of firm, it cannot operate without being available on Amazon, for example. I mean, that's the case that we're talking about. So I think that I think should be given some thought. Yeah, and finally, I would echo the call for a work on exclusionary, on exploitative abuses. I think it's not maybe guidelines, but maybe then it's more about bringing the cases. And I think we need to be prepared also from a geo-economic perspective that we were sometimes used that Western firms are the lead firms in supply chains. We now see that e-commerce platforms from other regions are kind of able to bypass that, and they're not dominant yet. So it's not at that point immediately relevant for abuse of dominance guidelines. But I think in the long term, I mean, we need to think about is there an exploitative abuse also if you kind of bypass, if you kind of undermine regulations, so product regulations and these kind of things, and at some point you need to start those cases because they will take some years anyway. I think you better start soon. Thank you.
Thank you very much, Uli. I mean, the point about sustainability, I think, is very important because sustainability is broader than just a quality dimension. And in the horizontal cooperation guidelines, I mean, explicitly the Commission also refers to collective benefits, which are broader than just basically benefits that are, taken by the consumers of the product. So it's not really related to quality only. Mm-hmm. And I think that's probably a reason why we need to have sustainability as a dimension also referred to in paragraph 55. And of course, the recent Booking.com case also raises interesting issues about narrow or wide MFN in case these are developed by dominant firms, and if this is something to be listed as well in the guidelines and the appropriate category. Right. So we move now to Irene Kaiser from SOMO. Irene, the floor is yours.
Thank you very much. Because I'm not. SOMO is not maybe super famous. That's why I think maybe an introduction is the right thing to do. So we are actually an organization that exists for 51 years. So we celebrated our anniversary last year, and we have been investigating the power of multinationals. That is our focus for 50 years. And so examples of what we've done during the last year is, for instance, that we filed a complaint to Booking on money laundering. We investigated Shell's disinvestment in the Niger Delta. So we're looking at tax avoidance. So all kinds of different dimensions, but we always look at where multinationals, how multinationals impact human rights and the environment. So that is our angle. So that is how we come into this topic. We never really engaged with competition, really the competition law. This is also because our organization is not necessarily looking for more competition. However, we do look for fair competition. And so then why did we enter this field? We saw there, like with tech companies becoming so extremely huge, we also saw that there might be an opportunity also with fair competition to look at it from a broader perspective. So that is how we came in, and we, for instance, engaged with the merger that was announced, but later Amazon abandoned that merger when Amazon announced that they wanted to merge with iRobot. And we also, for instance, another thing that we engaged with was, for instance, that we have been looking at food commodity traders for a long time, but then Russia invaded Ukraine, and we thought, like, this is a new time to also look at it. So we attended a few earning calls of food commodity traders, and then found out that they were actually saying out loud that they thought that this multi-crisis happening in the world was a big business opportunity for them. So they were expecting higher prices, and that was when we got into the topic and wrote a report on hungry for profits, and we described how food commodity traders made so much more money during making use actually of that crisis. And that's also when we stumbled upon the big announced merger between Bungie and Viterra. And from our research, we saw big issues with that. So we also thought like this is also a new way, we wanted to engage with that with the European Commission. And maybe talking a bit like about experience. So we're an NGO, so we're doing research. We're like sometimes we contribute to protests, but we also do strategic litigation. We do all kinds of things, everything that can help us to change the world, so-called. So we also had a conversation with the European Commission. That might be interesting also to say a few words about like how these. I think it would be very interesting if both worlds do come together, but that is also something that can be, a challenge maybe, or maybe we both still have to learn a bit. So it became a very technical conversation where we described everything of our research, and then the European Commission asked us like, but if we sell those assets, and if the assets in that country are sold, what do you think? So like this was like a conversation that we're like not like, the European Commission is sitting on a pile of evidence that we don't have. We just really have to rely on everything that is public. So that was like, we tried to explain like that's not really where we come from. Which was also interesting that they then asked like, can we use your report? Is it public? And we're like, if you know an NGO, like there's nothing more that we want than as much people as possible to read our report. So we felt like it's definitely public. It's please read it. So that was like an example, I think, where I think like, okay, there's like, maybe room for where both worlds can still improve. And I also want to thank this group, the Inclusive Competition Forum, for writing an excellent report that like shed another light on this case, and that actually showed like, a phase 2 investigation could have been a really good thing to do, which unfortunately did not happen in this case. So speaking from like decades of experience, not myself, but my colleagues, it's also like there's also one thing, if you engage then with like very technical areas, we also always have to be a bit careful. So for instance, we engaged a lot with on tax avoidance, also with tax experts and Ministry of Finance and all of that. But then we saw this is what we learned in the Netherlands also, is if the conversation becomes too technical, then you sometimes also lose something as an NGO. Because in tax avoidance, we got like really entangled in very technical conversations. And there's then the risk that you win small battle, but you lose the big battle of, and which is also something that is maybe good to keep in mind now with what we're talking about today. The evidence that we found during more than 50 years is showing that dominance as such is also a problem. And so it's like abuse of power is not a surprise. It's really true for multinationals. So you could also read the Draghi report, for instance, with those eyes, that you think, if like fair competition, or the authorities will are already struggling to be very effective, since they are dealing with less capacity. But if you also if we're going to do what Draghi says, and if we're really are trying to and build European competitors, then that might be a struggle that we will not win. So that my
Thank you very much, Irene, also for raising the point that we need to, and this is also a point made before by Claire, that in terms of the language, communication, narratives, I mean, it's not just, communicating between experts. This is a public document. This is a document that needs to eventually, push for the value of competition to a broader crowd, audience, and obviously we need to be very careful and engage with also the wider civil society. Last but not least, and I guess, there has been a lot of discussion about data, about privacy. We could not have with us Privacy International. So, Johannes, the floor is yours. Johannes Kvakas.
Thank you, and thank you very much for the opportunity to speak at this crucial juncture for competition law and its role in shaping the European future. As we reflect on the reform of Article 102 of the treaty and the draft Commission guidelines, I would like to explore two specific points that I believe closely relate to each other. The first one relates to exploitative practices and echoes the point raised by several of the previous speakers, both on this and previous panels, in their great interventions, namely the absence of explicit guidance on exploitative abuses in the current draft guidelines. And the second point I would like to make today pertains to the wider connection of competition law enforcement and the so-called European social contract, particularly in the digital age and especially in the context of current disbelief or public distrust in European institutions. So to begin with, let's start with the first point. Indeed, I believe it's quite unfortunate that the draft Commission guidelines do not really discuss exploitative abuses. In fact, in the 56 pages of the guidelines, the term exploitative abuse is mentioned only once. That is in paragraph 11, if I'm not mistaken, and basically it's just to signify that while the guidance and presumptions and so on contained within the guidelines are meant to apply to exclusionary abuses, they might also apply to other abusive behaviors such as exclusionary abuses as well. And then there is a footnote accompanying the mention of exclusionary abuse, which I think states for the avoidance of doubt, the same conduct by a dominant undertaking may have both exclusionary and exploitative effects. And all this is very promising for sure, but at the same time I think it's quite cryptic. Unfortunately, I don't possess any particular insights into why the draft Commission guidelines focus so much on exclusionary abuses and seem to ignore exploitative abuse too, although there have been several inferences so far, and we also heard some sort of justification from the European Commission representative earlier on. Perhaps one could guess or one could add that it might have something to do with the fact that exploitative abuses are not explicitly mentioned in the text of Article 102, or perhaps that the Commission thought that it had already gone too far when it comes to exclusionary abuses by pushing this guidance forward and putting so many things and principles in paper, or perhaps that exploitative abuses are something for academics to indulge themselves in and not so much for practitioners or courts to interpret. So the Commissioner perhaps preferred to take a step back. Or perhaps it's more or less all of the above points. However, I don't think we can talk about the proper reform of Article 102 without, and therefore introducing these draft guidelines without discussing exploitative abuses. And the draft guidelines are already taking a very important and crucial step forward when it comes to competition law enforcement, and they're really bringing these standards up to speed and up to date, and they should definitely be welcomed. However, exploitative abuses should by no means be ignored in the text of the guidelines. And this is further supported, in my view, by the second point that I would like to make, and that pertains to the role of the European Social Charter in reshaping Article 102 of the treaty and the relationship that it should have, if any, at all, with Article 102 and its enforcement. Again, if it should have any relationship with competition enforcement. Now, I'm no expert on the European social contract, and I have certainly been unable to become one within the last few days in preparation for this panel, as there exists not so much material on the topic, and the main contributions on this are not so much on the from the angle of competition law, though some commentators do discuss it. However, what most of discussions around the European social contract seem to have in common is that our understanding of this notion basically incorporates two main elements. So we understand the European social contract as incorporating two main elements that most commentators include in their analysis. That is the need to address social inequalities, especially around social welfare, understandably. And second, the strengthening of community values or the strengthening of democracy more generally. Now, unsurprisingly perhaps, these are quite general or vague terms, the draft guidelines do not contain an explicit reference to the European social contract. Nevertheless, there is another Commission document that does refer to the European social contract, and it's one strategic foresight report, which is a document that is meant to explore the future for policy making and the relative landscapes and how they might affect European policy making. And if we take a look at the quite recent 2023 report, we will see that there is a kind of quite extensive discussion around the European social contract, and the report argues that it is currently at threat. And to support this claim, the report puts forward several arguments, including, for example, that there is a strong public distrust in EU institutions, referring specifically to a Eurobarometer survey where 49% of EU citizens believe that their voice does not matter for the EU, as well as the report also citing inequalities in the context of digital divide or inequalities in the context of algorithmic discrimination. Now, the question that arises, of course, is what do these two concepts have in common, namely the fact of the external, namely the fact of the European Social Charter and its involvement in the draft Commission guidelines on the one hand, and the social inequalities or biases experienced by European consumers or European citizens. And I see the issue becomes more clear when we take another look at the exploitative abuses within the context of the guidelines, or more generally within the context of competition law, and how, compared to exclusionary abuse, we see them more often than not having the consumers as a direct target, or to put it differently, the consumers being the one directly threatened by the consequences of this anti-competitive conduct. And I think this is ever more true in the context of online markets or online services, where consumers directly engage with dominant online platforms. And I'm just going to include this point because the Draghi report has been mentioned quite a few times today from several perspectives, especially when it comes to how Europe can conquer, let's say, the quantum computing or AI sector. At the same time, the Draghi report also puts forward several arguments or several ideas, one of them being that data protection legislation or the GDPR are really an obstacle when it comes to innovation, which I completely take issue with, and I think it's not the case. We should consider data protection legislation or regulation not really a barrier to innovation, but more like a safeguard in ensuring that consumers can properly enter the digital era. And the reason I'm mentioning this is again because this is just another example, in this specific context might be data protection legislation or so on, of how we should be addressing inequalities, especially in online platforms, digital areas among consumers. And if the EU were to properly, let's say, address those issues that lie at the heart of the so-called European social contract, then an Article 102 reform and enforcement would definitely be one of the best and most appropriate ways to do it, including these guidelines. And the question, therefore, that remains, considering what we have just discussed, is basically whether there can be whether these objectives can be achieved without explicitly mentioning the European Social Charter. Perhaps it can, and more generally, whether these objectives can truly be achieved.
Is going to follow them.
Whether these objectives can specifically be achieved if we have to resort to legislation such as the GDPR, the AI Act, or even competition laws? And finally, and more generally, to sum up, whether we can properly serve a renewed European social contract by mentioning or including explicitly and specifically and taking a stance on exploitative abuses in the 102 guidelines. Thank you.
Well, thank you very much, Johannes. And I think you raised a number of issues, in particular the connection between the Article 102 and the broader competition law acquis with the economic and social constitution that we have in the EU, including obviously the text concerning the Charter. And I think this is definitely an important point, to the extent that, from a defense perspective, I mean, in cases, the fact that you have the protection of property rights in Article 17 of the Charter has been used as an argument for less competition law enforcement. So I think, to the extent that we accept that this is important as a defense, it can also be important to take that into account to enforce competition law in terms of, to preserve the social contract. The other thing, actually, I noted, and this is a little bit more also what was mentioned before about, I think, from Iran and from Uli concerning the concept of power. When we think about the digital economy, and in particular, data, I mean, the Commission has a few references on data and data-driven advantages that could be barriers to entry. What is, however, interesting, and I've been reading recently a draft paper by one of my colleagues at UCL, Dr. Veal, who was basically saying, well, data is important, but actually we missed the point about looking to the broader data infrastructure that might exist to enable the use of the data for anti-competitive reasons. I mean, it could be eventually, and hopefully I interpret him correctly, could also be the data capabilities that the companies will have. So just having access to data alone is not enough, or the data, the accumulation of data is not the only thing that we need to focus on. It's also the infrastructure that is enabling the most effective use of this data. And I feel that reading the relevant paragraphs of the Commission guidelines, in particular footnote number 60, that this is more about the data-driven advantages. It doesn't really, from having the accumulation of data, but it doesn't take into account this broader infrastructural advantages that might exist, and possibly it's something to open up in order to enable a better understanding of the power of the dominant position of the firms in that context. Now, we have some minutes for questions in case of comments. I know it's a very long day, and obviously we have the drinks waiting for us. We enable more discussion. But if there are any, I see there is a point by Simon, so I guess we have to share there should be another mic to share, but otherwise I'll give my mic. Yes.
Just a very narrow point, very specific point in response to Yanis's, that is the other Yanis, who was concerned that maybe the Commission wasn't covering exploitative abuses because there's no reference to exploitative abuses in 102. Well, it's not a reference to exclusionary abuses either. As such, what there are is a number of examples. And whilst you could debate in particular contexts, some will be exclusionary, have an exclusionary effect, some will have an exploitative effect. What I think is unequivocal is that the vast majority of the examples there are exploitative. Maybe exclusionary, but the vast majority are exploitative. And that's why it's another reason why it's so peculiar that hasn't been enforced in the way that one would have expected, if just reading the treaty afresh.
Any other question or comment? I see many people just looking to the door, so thank you very much again to our speakers and also to you for staying so late on a Friday afternoon in Brussels. And please join me in thanking them formally with a round of applause. So we have some drinks waiting for us outside, so looking forward to interacting more with you outside.